Hey, guys. Sorry, I'm a few minutes late. Set this up at the last minute. Welcome to this impromptu Saturday. Very brief. I doubt we'll be here 15 minutes, folks. Episode of the Law of Self-Defense. I am so glad all of you could be here with me today because I have what I think are probably some provocative thoughts about yesterday's dismissal. Certainly, these are thoughts that I am not seeing reflected among my lawyer peers on social media. Even people I like a lot, respect a lot. I'm seeing what seems to me and some odd kind of emotive takes on this dismissal of the Adam Baldwin involuntary manslaughter trial case. Let's see. And I think part of that is because the word Brady was thrown in. Brady, of course, is a U.S. Supreme Court decision that has to do with the obligations of the prosecution to turn over evidence to the defense in discovery if they have evidence that's exculpatory or impeaching about a case. This was the grounds for the dismissal of the case against Alec Baldwin for involuntary manslaughter and the death of Helena Hutchins, cited by the judge yesterday. And the judge, let me pull up her picture so we can. Did I just lose the show? Uh-oh. Am I still broadcasting? I have so many tabs open. I'm still live, right? Okay, good. Hold on, folks. I'm getting a little organized here. Kind of. Let's see. Oh, I lost my window. All right, give me a moment, folks. I apologize for this. 1, 2, 3. I can't find. Oh, here I am. Found it. Found me. I found me on my computer. Took a little while. Sorry about that. The word Brady has been thrown out by this judge. That was the basis, the legal foundation for her dismissal of the charges of involuntary manslaughter, dismissal with prejudice against Alec Baldwin, and specifically with reference to the Teskey ammo. The Teskey ammo was ammo that was brought into the Santa Fe Sheriff's Office by Troy Teskey, claiming that this might match the round that killed Helena Hutchins. He didn't know. The ammo he had never been in New Mexico. There was no evidence it had ever been in New Mexico, had ever left his home state of Arizona. But that was it. And apparently when it was brought in, it was filed at the Santa Fe Sheriff's Office under a different case number, so that when discovery was conducted for the Alec Baldwin prosecution, this Teskey ammo, sounds like pesky, right? But it's Troy Teskey is his name. This Teskey ammo was not shared with the prosecution. With the defense. Something the defense claimed to have discovered like yesterday. Maybe the night before, I forget, but that kind of time, mid-trial. The jury had been sworn, the trial had begun, double jeopardy had attached, and the defense stands up, says, "Your Honor, we have a big problem. We were never told about this Teskey ammo. We just discovered it now. This is a Brady violation, and the appropriate sanction in this case is dismissal of the charges." And then there was a lot of talk off camera, so I couldn't hear what was being argued. Ultimately, of course, the judge ended up with dismissing the charges with prejudice. And as a criminal defense lawyer, all defense lawyers, all lawyers generally have kind of a reflexive, emotive response to claims of Brady violations. Because, of course, suppressing, hiding exculpatory evidence from the defense would be the easiest way to rig the game in favor of prosecution. And it's not fair. And certainly as a defense attorney, I want every scintilla of Brady evidence shared in discovery, especially if it's favorable to my client. No question about that. I place infinite value on Brady and the legal and public policy that Brady stands for, and all the related cases, Giglio, all of them. Okay, I don't think the state should be privileged to suppress, hide evidence that's favorable to the defendant. So put that all on the table. And so whenever we hear something called Brady material, it's a Brady matter. What our brain immediately tells us is that this was an unjust suppression of favorable evidence, evidence favorable to the defense by the state. And that's reprehensible. That's disgusting. That's framing someone. That's horrific. It should be horrific to any person with any sense of moral balance. So when we hear something called a Brady violation, we respond it's easy to respond in a very emotional way because of how terrible it is. It would be like, I can't say these words on social media because but just imagine other horrific crimes that would be committed. Someone's accused of them. Even just the accusation is enough to taint that person's reputation, right? That's kind of the effect that an accusation of a Brady violation can have. But here's the thing. Just like an accusation of contemptible conduct against an individual is just an accusation, a claim of a Brady violation is just a claim. And I think we owe it to ourselves, to society, to the justice system, to Brady, to be prepared to ask, but is it a Brady violation? And when I look at what's claimed to be a Brady violation here in this Alec Baldwin case, I just don't see it. I literally do not see it. And I've been unable to find anyone who can explain to me, not in a law-based argument, okay? I get lots of emotional responses on Twitter and such. But in a law-based argument, how this is actually a Brady violation, this supposed suppression of these Teskey rounds. And first of all, I think there's an argument to be made that it was completely innocent that these rounds were coded under a different case number for reasons I'll talk about. But even if we presume it was intentional, even if we presume that the state should have shared these Teskey rounds with the defense, and by the way, I would say that they should have shared them, if only to avoid this kind of trouble. I don't think it helps the defense. I don't think it helps the state to not share them. I don't think the state had any motive not to share these Teskey rounds with the defense, because I don't think they make any difference. I just don't think they make any difference, because for something to make a difference, for a claimed fact or piece of evidence to make a difference in a trial, it has to be material to the legal issues in dispute. It has to have the potential to affect the outcome of whatever legal argument is being made, whatever the legal algorithm is in that particular case. And in a criminal case, that's typically the criminal charge and whatever legal defenses would rationally and plausibly be made in the case. And it's not true that every piece of potential evidence is material to a case. So just look at the set of Rust. Look at the props truck. Was every item in that props truck, the costumes for unrelated actors? Was the broom in the corner? The dustpan? Was that entered into evidence in this case? I doubt it. Was the church pew that Alec Baldwin was sitting on when he shot Helena Hutchins, was that bench entered into evidence? I doubt it. Should the whole church have been confiscated and entered into evidence? Does that make any sense? The only things that are evidence, material evidence in this case, are things that would change the legal algorithm. In this case, the criminal charges and the legal defenses. And what are the criminal charges? Well, we have those here. Well, let me pull it up. In the indictment. Two alternative theories of involuntary manslaughter. One is that Alec Baldwin handled the gun criminally, unlawfully. Criminal handling of a firearm is a misdemeanor offense under New Mexico law. When you commit an unlawful act, and that would be this, negligent handling of a firearm, a misdemeanor. When you commit an unlawful act and someone dies as a result, it's involuntary manslaughter. If the unlawful act a misdemeanor. If the unlawful act were a felony, it would be felony murder, right? But that's not what anybody's claiming here. So one theory of involuntary manslaughter is that Alec Baldwin's handling of that gun was negligent. Therefore, a misdemeanor crime, therefore unlawful, therefore Helena Hutchins' death that resulted was involuntary manslaughter. Notice it's all centered on Alec Baldwin's handling of the gun, right? The alternative theory of involuntary manslaughter is the handling of the gun without due caution and circumspection. It's an inherently dangerous instrument. If someone dies because you weren't handling it with due caution and circumspection, that's involuntary manslaughter. Here, the only real difference is the state doesn't have to prove the underlying predicate crime of misdemeanor negligent handling of a firearm. But again, we're talking about Alec Baldwin's handling of the firearm. That's the predicate fact pattern for both theories of involuntary manslaughter. The only charges that Alec Baldwin is facing in this case. And the facts of him handling the firearm are largely undisputed. Right? The facts are, as claimed by the state and really undisputed by the defense, that Alec Baldwin was holding what he knew to be a real gun, capable of firing real bullets, that he pointed that real gun directly at Helena. And we know that's true, by the way. We know he knew he was holding a real gun because he said so in his police interview the day of the shooting. So that's incontestable. That he knew he was holding a real gun capable of firing real bullets. That was dangerous. He said that in the police interview too. These guns are dangerous. They're real. That he pointed that gun directly at Helena Hutchins, that's incontestable because the bullet fired from the gun directly struck her. It didn't ricochet off something. No one's claiming that. So the gun was obviously a real gun capable of firing real bullets in Alec Baldwin's hand. He pointed directly at Helena Hutchins. That he cocked the hammer of the gun. Well, he says that. So that's incontestable. And then that he pressed the trigger. Now, frankly, I don't think the pressing of the trigger is required for a finding of lack of due caution and circumspection or negligent handling of a firearm. I think if you point a real gun at someone, cock the hammer, and it discharges, that's enough. You know, assuming you have no legal justification for the shooting as here, that's enough for reckless involuntary manslaughter. But let's add in the pressing of the trigger. The only evidence inconsistent with Baldwin having pressed the trigger is Baldwin's own self-serving statement. When we have photos like this from the same day of the event, in the same church pew, where he's blocking out the same scene, his fingers on the trigger. When every examination of this gun by experts, the gun functioned normally. Could not drop the hammer to discharge a round unless the trigger was pulled. When for days beforehand, Alec Baldwin himself is using the gun and there's no indication of a malfunction. When he told people in interviews, the only thing wrong with the gun was there was a live round in it. So I would suggest the overwhelming weight of the evidence is that this gun could not be discharged without the bullet pressed. Those are the material facts of the criminal charge of involuntary manslaughter in this case. What is not a material fact here? What is not a material fact? Where the rounds came from. Where the rounds may or may not have come from is irrelevant to any of the material facts in this criminal charge. They just are. If the round had come from Troy Teskey, if the round had come from Thel Reed, if the round had come from Helena Hutchins, if the round had come from Seth Kenny, if the round had been flown in by a ferry with gossamer wings from a local sporting goods store, the sourcing of that round might have implications for other people, like Helena Hutchins, facing charges of reckless involuntary manslaughter on other fact patterns. But the source of the ammo has nothing to do with the elements of the criminal charge against Alec Baldwin, nor of any legal defense, because there really isn't a legal defense. The only substantive legal defense here is if a juror were to believe that all those facts were true, that Alec Baldwin knew he was holding a real gun capable of firing real bullets, pointed the gun directly at Helena Hutchins, cocked a hammer, pressed the trigger without obviously ensuring there was no live ammo in the gun, because a live round fired killed her, and they just don't feel that's reckless conduct. I mean, a jury could do that, but it still has nothing to do with where the round came from. So therefore, where the source of the round is not a material fact in this case. And therefore, evidence about where the round came from is not material evidence in this case. And if it's not material evidence, it can't be relevant evidence. And Brady only applies to material evidence. Brady applies to exculpatory or impeaching information and evidence that's material to the guilt or innocence or, after conviction, punishment of a defendant. But if it's not material, it doesn't fit into the jigsaw. It's not part of this puzzle. There's lots of evidence, things that could be evidence from this scene that is much more proximate to the actual shooting than the Teskey rounds that had never entered the state of New Mexico until Teskey brought him in during the Hannah Gutierrez trial, than any evidence about where the round came from. What about the costume that Alec Baldwin the boots he was wearing? Is that material evidence to this criminal charge? How could it be? It doesn't make any sense. It's akin to if Alec Baldwin had been charged with involuntary manslaughter for the reckless operation of a motor vehicle. He recklessly ran somebody over with a car. And the claimed suppressed evidence is the source of the gasoline in the car. Obviously, the car had gasoline in it. Does it matter where it came from? Is that a material element in a charge of reckless operation of a vehicle? Where the gas came from? Is it a material fact what the source of the ammo was in a case of reckless handling of a firearm? Does it matter? I don't see where it's material. And if it's material, I don't see, if it's not material, I don't see how it can be a Brady violation. Now, I don't claim to be an expert on Brady law. I'm just a small town lawyer applying legal reasoning. And I'm amenable to persuasion. So the reason I wanted to lay all this out in this relatively short video today, I had hoped to keep it at 15 minutes. We're already almost 20 minutes, is because I wanted to give everyone a heads up so they can prepare, if they wish, to make counter proposals, counter arguments to my understanding of all this in our webinar tomorrow. So if you were watching my coverage, you know that we have been planning it was supposed to be a mid-trial recap of this trial on Sunday, tomorrow, in the afternoon. We were going to, what's happened in the trial so far? What are some of the highlights? What can we expect coming in the next week? Who's on the witness list? all that kind of stuff. But now, of course, the trial's over. So this will be more of a Sunday afternoon trial wrap up. But what I really want to focus on, given the nature of the outcome of the case, this dismissal with prejudice, is this dismissal with prejudice. I mean, listen, who would be in the best position to explain what the materiality is of these Teskey rounds to this case? Maybe the judge, right? Maybe the judge, maybe Judge Summer would be in the best position to explain how these Teskey rounds are material to the case. Well, she spoke to materiality when she gave her order from the bench dismissing this case. So I've got her recording here. And I just advanced it to where she talks about materiality. I'm not upset about the outcome, folks. This is actually good for me, this outcome. I'm not upset about it. I'm just trying to understand it from a legal perspective. So here's a recording of the judge giving her oral order dismissing this with prejudice, the portion where she talks about materiality. And she says the word materiality, but it's just like a summary finding of materiality. She doesn't actually explain why it would be material to any of the elements of the criminal charge, to have anything to do with Alec Baldwin's handling of the gun. So here's that recording. Let me make myself small.
Is the evidence material? While post-trial discovery of evidence under Brady requires a reasonable probability that the result of the proceeding would have been different, discovery of evidence during trial requires an evaluation of whether the late tender has impeded the effective use of evidence in such a way that it impacts the fundamental fairness of the proceedings.
So she's saying these words, but it doesn't mean anything to me because it's not attached to any context of the actual criminal charge.
Is State versus Huerta Castro. This evidence is material. The late discovery of this evidence during trial has impeded the effective use of evidence in such a way that it has impacted the fundamental fairness of the proceedings.
So she sounds like she's just quoting from, an appellate court decision there, but she's saying nothing about how the evidence connects, is actually material, proximate in any way to Alec Baldwin's handling of the gun.
The defense is not in a position to test the state's theory as to the source of the live rounds that killed Ms. Hutchins.
That may be true, but the source is immaterial to the criminal charge. There's nothing about the criminal charge that has anything to do with the source of the ammo. And then we have Erlinda Johnson. Erlinda Johnson, it was the co-prosecutor who abruptly resigned at the end of proceedings yesterday before this dismissal was announced, and just before Morrissey took the witness stand to make a record of all this. And she talks about materiality too, with utterly zero substance. So she knows materiality is a required element of Brady. That's what the judge was just talking about. But they never explain how this Teskey ammo is actually material. Whoops. There we are. All right. So here's the Erlinda, the interview with this Cuomo guy. I don't remember his first name. And I forwarded it to the point where she mentions, he asks her, why did you leave? And she starts talking about the elements of Brady. And she touches upon materiality for like half a second.
So you believe it should be dismissed? Explain to people who don't understand anything about the law, why did you believe this ammunition was so important for the defense?
Good question.
So
Excellent.
obviously, you're a lawyer, I think. Brady versus Maryland imposes requirements on the prosecution to turn over evidence. The rules of criminal procedure impose those requirements, those duties as well. So is the evidence material? That's number one.
Okay.
How timely is the disclosure?
Wait,
Without question, this was grossly untimely.
You just skipped over materiality.
Number two, is it material? So
Okay.
the question is, could the defense have made some use of this evidence in their defense?
Could they?
And like I said, we as prosecutors do not get to make that decision what the defense is going to be.
No, but prosecutors make those decisions all the time. For example, the prosecutor in this case, didn't take the whole church into evidence and turn it over to the defense and discovery. Prosecutors make decisions all the time about what they believe to be material evidence. I mean, not every known fact in the universe is a material fact in any given case, right? The prosecution in every case doesn't take the entirety of Wikipedia, put it on a hard drive, and hand it to the defense. What's discoverable evidence, shareable evidence, Brady evidence is evidence that's material to the criminal charge or a defense. So if someone can explain to me how this Tuskegee ammo is material in any plausible way to either the criminal charge or any prospective plausible legal defense here, that's what I'd like to hear. So I'd like to hear that. We don't have time for this today, and I guess there's some Trump news. Everybody's excited. We can't talk about that today. We don't have time. I don't have time. But I want to talk about it tomorrow in our Alec Baldwin manslaughter trial wrap-up webinar. Now, in this webinar, we're doing this webinar because I want to be able to say and do things I'm not allowed to do on social media. So, especially some of the prizes we're giving away. We're giving away $10,000 worth of prizes, folks, including one very, very special gift that I can't mention on social media. That's one of the reasons we're doing this as a webinar. Now, the webinar is 100% free. The way, so it doesn't cost a penny, but because I'm doing it as a webinar, you do have to sign up. You have to register to get, login credentials. You can do that at lawofselfdefense.com/trial recap. lawofselfdefense.com/trial recap. What happened to my trial recap button? Here it is. And when you click over there, you'll come to this page. There's a big blue button. Register my 100% free spot now. And what we're going to do is we're going to spend the first roughly third of the webinar talking about these questions I just raised. How is this actually a Brady violation that warrants dismissal with prejudice? Where is the materiality of the Tesco ammo to any element of the criminal charge or any legal defense to the criminal charge? And I'm encouraging people to gather their evidence and join me on the webinar and explain it to me like I'm a 5-year-old, because I just don't see it. Then the second of the 3 segments, we're going to have my buddy Adam Baldwin on. So, of course, you all know Adam Baldwin, Independence Day, Full Metal Jacket, Firefly, Serenity, The Patriot, Chuck, The Last Ship, tons of stuff. Great actor, great guy, good friend of mine, been a friend for many, many years. And of course, has decades of experience handling guns on movie sets, on TV sets on Hollywood. He's going to share his experience handling those guns, what the rules are for handling those guns, what common practices actually are in Hollywood. Does Hollywood have separate rules that are, different than what the criminal law demands for safe handling of a firearm, and so forth? So he'll join us for the second of the 3 segments of the show. And the third segment of the show is when we're giving away the $10,000 worth of prizes, including one very special gift. Now, for those prizes, you do, and I can't say what the gift is, the special gift on social media, because I'll probably get canceled. But when you join us for the webinar, we'll tell you right away what it is. So you'll know whether or not you want to stay and be a prospective winner of those. And that's the third segment of tomorrow's webinar. So we'll do the $10,000 worth of gifts. You do have to be present to win. It's not enough to have registered. We're going to pick a name from the list of people in attendance at the webinar, and you have to claim your prize right then. We'll tell you where to email to claim it. And if you don't claim it pretty promptly, we're going to pick another name. So you have to be present and paying attention. That's what we'll be doing tomorrow, 2 p.m. Pacific time, 5 p.m. Eastern time, for our Baldwin trial giveaway event. But you do have to register. lawofselfdefense.com/trial recap. It's free. So we'll do kind of How is this dismissal with prejudice legally sound? We'll do have Adam come in and talk with us. I'll take questions for Adam too, if you want to post questions. There'll be lots of opportunity for Q&A. And we'll talk, the third part, we'll talk about lessons learned, things you can do to make yourself hard to convict and easy to defend. Lessons learned from this trial about how you can make yourself harder to convict. And then we'll do the $10,000 worth of prizes that we're giving away. So I hope a bunch of you join me there. lawofselfdefense.com/trial recap. I think it'll be great fun. And that's what I wanted to share with all of you today. Half an hour. That's close to 15 minutes. Only 2x. So until tomorrow, I just want to remind all of you that if you carry a gun so you're hard to kill, and I'm not going to take any questions today, folks. The questions are all for tomorrow. If you want to see some of my perspective on all this, you could look at my Twitter feed. In fact, I can share kind of in a nutshell my issue. This is kind of my core take on all this. Let's see how I can. Regarding the Alec Baldwin manslaughter dismissal based on a purported Brady violation by the prosecution, the claim of evidence improperly withheld from the defense, the supposedly withheld evidence had to do with the source of the round that Alec Baldwin used to kill Helena Hutchins. I'm struggling to understand how the source of the bullet is material to Alec Baldwin pointing what he knew to be a real gun at Helena Hutchins, cocking the hammer and pulling the trigger without ensuring no live rounds in the gun, killing her. After all, if a drunk driver commits involuntary manslaughter by running over a grandmother in a crosswalk, is it material where he sourced the gas for his car? And if it's not material, it's not Brady material, subject to disclosure. In which case, this Alec Baldwin dismissal is legal error. That's how I see it. But I'm keeping an open mind. I'm hoping some juicy arguments, law-based arguments. I mean, you can come and yell at me in the comments if you want, but that's not going to be compelling. Law-based arguments. All right, folks. Until I see you all tomorrow, I'll just remind you that if you carry a gun so you're hard to kill, that's why I carry a gun. So I'm hard to kill, so my family is hard to kill. So you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until tomorrow, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.